Good morning, everyone, and welcome to the sixth meeting of the Education and Skills Committee in 2020. Can I remind everyone present to please turn their mobile phones and other devices to silent for the duration of the meeting. Our first item is a declaration of interest by our new committee member. We welcome Alec Neil to committee and ask him to declare any relevant interests.
No special interest other than what's my register of interest, convener.
Okay, thank you very much. The next item of business is a decision on whether to take the work programme on next week's agenda in private. Are members content to do so? Thank you. Thank you. We now move to agenda item 3. Can I first welcome to committee this morning Alex Cole-Hamilton, MSP, and Liz Smith, MSP, both of whom may wish to contribute to the proceedings, but obviously won't have a vote in any of the proceedings at stage 2. We also welcome to our consideration of Disclosure Scotland Bill Minister for Children and Young People, Marie Todd, MSP, and to the officials. Everyone should have a copy of the bill as introduced in the marshalled list of amendments and the groupings of amendments, which sets out the amendments in the order in which they will be debated today. So we move to PVG Act, participation of persons aged 12 to 15 in the scheme, and I call Amendment 209 in the name of Jamie Green, grouped with Amendments 210, 211 and 212, and I invite Jamie Green to move Amendment 209 and speak to all the amendments in the group.
Thank you, Convener. I move Amendment 209 and I'll speak to amendments in my group. Members will bear with me. Obviously, I didn't participate in the Stage 1 proceedings, but I have done my homework and my thanks to my colleague Liz Smith for working with me on handing over some of this work. In essence, what this group of amendments seek to do is strike a balance of some of the evidence that was heard in Stage 1 and also concerns that have been raised by a number of stakeholders, including the third sector and voluntary organisations who have been in touch since I joined the committee. Members will recall that during the Stage 1 evidence, several witnesses did raise some concerns about the bill's proposal of implementing a mandatory PVG scheme for those aged 16 or over to carry out regulated roles. Several witnesses were concerned that under the current proposals, by setting 16 as the minimum age for obtaining disclosure, there may be the situation where those under 16 would be unable to obtain a PVG where they currently do have one. Members may be aware that there are around 300 young people under the age of 16 who currently are part of the scheme and who do undertake a number of roles that may be considered as regulated roles. In order to put some evidence around this, I spoke to a number of organisations who got in touch and would like me to express the following from them. The first is from Interest Linked Borders, who said, and I quote, and I'll pass these to the OR thereafter, volunteering organisations like ourselves will not involve anyone who might have a criminal record in regulated roles unless they have a PVG membership. So the actual result of the bill will be to prevent those under 16 being in regulated roles. The Scottish Volunteering Forum, who I know a number of members work with, noted some other concerns. They said that given that there is a proposal to make a PVG scheme member legally mandatory for doing regulated roles, a lot of organisations would interpret that as meaning that people under the age of 16 would no longer be able to do any voluntary work with voluntary groups. And a third organisation got in touch, the RYA, who do a great deal of good work in my region, said there is a lack of clarity in the messages from the information being promoted. We believe the contradiction between a club being required to ensure that a volunteer is a scheme member if the role is regulated, and an under 16-year-old undertaking a similar role not being permitted to join the scheme will create confusion. This could well deter clubs like ours from involving young volunteers and as a consequence adversely affect opportunities for young people instructing and coaching our club-based activities as well as those of other sports with similar developmental roles. So in essence, on the spectrum of making the scheme mandatory for under 16-year-olds and over 12-year-olds, on the balance, when my colleagues researched this, we came up with some middle ground that in effect gives ministers the ability to allow under 16-year-olds to participate in a regulated role if it appears to them that from the information contained in the application that it is appropriate for them to participate in the scheme. So that in essence is the rationale behind it. This would give discretion to Disclosure Scotland the flexibility to allow under 16-year-olds to apply for a PVG in specific circumstances. It's not a blanket or mandatory reduction of the minimum age, but it would allow organisations some flexibility if they would like this extra level of vetting for their young volunteers, as is currently the case, giving them that reassurance that under 16-year-olds can undertake regulated roles.
Thank you. Do any other members wish to make comment? Mr Johnson.
Thank you, Convener. Can I begin by saying, I very much understand the reasons for bringing this forward. I think voluntary work is hugely important, and I think young people being involved in voluntary work is also very important. However, I do have a number of concerns about these amendments as they stand at the moment. And I think first and foremost, I think is looking at the way that the bill is structured and the way it's intended to work, which is regulated roles, and the roles which require to be regulated ones which permit and indeed require as a necessary part of their act unsupervised access to vulnerable adults and children. And I think therefore the question that occurs to me is whether it is ever appropriate for people under the age of 16 to have such unsupervised access to children in particular. And I think based on what Mr Green was saying, the thought there is such as sport, coaching and other activities, sporting activities and leisure activities such as that. And I think in those circumstances that the key question is who is providing the supervision of those activities. And I think that as set out, my understanding is that first and foremost that supervision would be provided by someone over the age of 16 with a PVG, which would still permit people under the age of 16. But what is more, I think the reverse of that situation, permitting someone under the age of 16 without that level of supervision, PVG or not, I think is certainly, I think, questionable in my view. And therefore, I think for those reasons, while I understand the motivation for it, I think it runs contrary to the intention of the bill, and indeed, potentially, I think, it is allowing for practice which I would question whether it is advisable in the first place. I hope that makes sense.
Mr Greer.
I echo much of what Daniel Johnson said. I've got a couple of questions that I would appreciate if Jamie Green would be able to answer, and one question for the Minister. I'm still not entirely clear and would appreciate some further detail on the scenarios or the roles in which you would imagine a Minister would judge it appropriate that a 12 to 15-year-old should be a member of the PVG scheme. And I'm wondering why PVG for these young people? We heard a lot about proportionality being key to this particular debate. PVG is a system of ongoing monitoring, so why not another disclosure product rather than PVG? I think Mr Green very fairly made the point around confusion, and that was something that we took evidence on, that the confusion around the participation of under 16s in what would otherwise be regulated work. My concern here is that were these amendments to pass and this system to come in, it would create further confusion, because you would have some 12 to 15-year-olds who did have PVG, some who did not, and there would be a further lack of clarity over who could and could not participate in this kind of work. And just finally, as a question for the Minister, I would appreciate if we could have just some absolute clarity around the committee's recommendation on this, because I think the committee did struggle to come to a clear conclusion. The evidence was relatively finely balanced, but the conclusion we came to was simply to ask the government to ensure that after an initial period of operation of this new scheme, that a review is conducted into the participation rate of under 16s. If the Minister can be clear that that will definitely take place, I would urge Mr Green to not press his amendments.
Can I invite the Minister to comment?
Thank you, Convener. Firstly, let me say I understand the intention behind Jamie Green's amendments. I appreciate the close scrutiny of the committee at stage 1 with regard to the introduction of a minimum age. However, I do not think, to answer Ross Greer's point, I do not think it is ever appropriate for children under the age of 16 to be subject to ongoing monitoring, and it is generally not appropriate to subject them to criminal record checks. The Bill's approach in relation to the disclosure of childhood behaviour will mean that very few disclosures will ever contain information in this age range, which will obviously have direct consequences for disclosure applicants who are still under the age of 18. As I previously highlighted before the committee, where children may pose a risk which could have led to disclosure, there are other more appropriate measures available to manage this, and evidence from organisations including COSLA and Police Scotland echoed the view that bringing children back into the PVG scheme is not a suitable response to manage that risk. As has been repeatedly highlighted by stakeholders, care experienced children are disproportionately represented in the justice and children's hearing systems, and that means any impact of children being asked to join the PVG scheme would fall hardest on that group. We've heard from Who Cares Scotland that young people already self-exclude from opportunities due to disclosure requirements, and I share the committee's concern that children could be denied volunteering opportunities, but it's already the case, as has been said by a couple of members, that voluntary organisations would not routinely allow children to undertake regulated roles without being supervised, and it's my view that introducing minimum age for PVG scheme membership will encourage organisations to build on those good working practices while also opening doors to children who might otherwise not participate. I want to stress that the perceived risk of organisations misinterpreting the change should be handled through training and guidance, not by continuing to subject children to ongoing criminal record checks as part of the PVG scheme. And again, I'm happy to provide my assurances that the Scottish Government will communicate in this area to make sure that children are not disadvantaged in gaining volunteering opportunities. Amendments 209 and 210 risk introducing uncertainty both for children themselves and for organisations as to when they should or could seek PVG scheme membership for children, and create inconsistencies in approach across the country. As the committee knows, a key element of the bill is introducing a mandatory PVG scheme for those carrying out regulated roles. That means, unlike Level 1 and Level 2 disclosures, those aged 16 and over doing regulated roles must be in the scheme. Now, to suggest that some children or roles undertaken by children should be in the PVG scheme but others should not be risks creating confusion, and that some roles in the scheme are more regulated than others, and there may also be a two-tier scheme created with adult scheme members being mandatory and childhood scheme membership only ever being discretionary, and that undermines the policy aim of the mandatory scheme. It would also compromise the training and guidance that we can provide as part of the transition to the mandatory scheme, and may result in more organisations than at present requesting scheme membership for 12 to 15-year-olds as a precautionary measure. I'm also concerned about the amendments to the offence provisions. So the effect of Amendment 211 is to amend Section 45C(3) of the PVG Act, inserted by Section 74 of the bill, so as to apply the offence of doing a regulated role without being a scheme member to 12 to 15-year-olds in circumstances where ministers have permitted them to be in the PVG scheme. However, as 45C only applies to carrying out or agreeing to carry out a regulated role while not a scheme member, and those 12 to 15-year-olds who participate in the scheme under Jamie Green's Section 45(4) would be scheme members, this amendment has no effect in this respect. Under 16s would still not need to be scheme members to carry out regulated roles unless they had already been accepted into the scheme. That seems circular. The effect of Amendment 212, which amends Section 45D(3) of the PVG Act, inserted into Section 74 of the bill, is to apply the offence of employing someone who is not a scheme member to do a regulated role to an organisation which offers a regulated role to 12 to 15-year-olds, where ministers have permitted the child to be in the PV scheme under Section 45. Participation in the scheme. However, as 45D only applies to offering a regulated role without confirming scheme membership, and Jamie Green's 45.4 would involve an organisation seeking scheme membership for a child aged 12 to 15. This amendment, again, has no effect in this respect. I am proud that Scotland has the PVG scheme, which provides not only the snapshot disclosure of criminal record offered by the Police Act disclosures, but also the ongoing monitoring of those coming into contact with the most vulnerable in society. That's why the Scottish Government is ensuring that it can offer more robust support to safeguarding through this bill. However, there is a reason that other countries have a minimum age and state disclosure. It is, as we have frequently seen in the Scottish Parliament, because it is appropriate to treat children differently from adults. We are, in fact, in the unusual situation here where we have a Conservative member arguing for continued divergence from the rest of the UK, and the Scottish Government arguing for us to remain aligned with the rest of the UK, because of course it is already the case that the rest of the UK, in the rest of the UK, organisations can't obtain standard and enhanced disclosures on children under 16, and those changes were made some time ago in England and Wales back in 2012 by the Disclosure and Banning Service, and in Northern Ireland in 2015. Those changes were made, citing concerns with compatibility with the UNCRC. In response to Ross Greer's concern, as I stated at stage 1, the Government is more than happy to work with bodies that represent volunteers in Scotland to see whether there is a change in the level of volunteering. There has not been a detectable change in the volunteering rate since those changes were made in the rest of the UK. I understand just how significant children and young people's volunteering is, and in fact children and young people volunteer at about twice the rate of adults. So volunteering is not only important for children, but it is important for Scotland, and we have to ensure that they continue to volunteer and that we don't introduce any barriers to that. As I've said previously, I would not want any child to be denied the opportunity to volunteer because of the stigma associated with the disclosure, and I'm concerned that subjecting children to the PVG scheme could present such barriers. In summary, I ask the member not to press any of the amendments in this group for the reasons I've set out. If he does, I would ask the committee to resist these amendments.
Thank you. Minister, can I invite Mr Green to wind up and press or withdraw the amendment?
Thank you, Convener. Can I thank members for their comments, feedback? It's very helpful. It's been, I think, constructive. Just to address some of them individually, I agree with Daniel Johnson. There are questions about whether it is appropriate for under 6-year-olds to be in unsupervised situations and regulated roles. But I think it's fair to say that the reality is there already are a number of young people who participate in a form of PVG scheme membership who may be in that situation. It's impossible to cover all scenarios, and I think we do talk often about the ideal world where, of course, it would never happen, but it does and it may. And I guess the point I'm making is that the volunteer organisations who were in touch said that they do have young people under 16 who are in those situations performing the same roles as those of 16 plus. And their questions to us are, what are you doing about those people? To answer some of the other points, can I thank Ross Greer for his feedback? I guess the mention of other disclosure schemes, he will benefit from perhaps understanding those better than I, but if there are other options available for under 16-year-olds to where there are organisations who would like that additional comfort in specific roles, if there are other opportunities available to them, so be it. But it would be helpful to know what those are and for that to be communicated to volunteer organisations who may not be aware of them. And can I thank the Minister for some very, very helpful comments. I think we all share the notion that volunteering is extremely positive. We do want to encourage it. The point of these amendments are not to create confusion, but clearly they are actually trying to address confusion that currently exists. Volunteer organisations would not be saying words like organisations may interpret that as meaning that people under the age of 16 can no longer do voluntary work with vulnerable groups. If they're saying that, then we need to be listening, Minister. And that's the point of these amendments, not to create confusion, but to clarify where confusion currently exists. So what I would say is, in response to the requests from Ross Greer about what happens after the bill's passed, this is stage 2. we have the opportunity now to better communicate with the voluntary sector about what the consequences of the bill will be to them and those who currently volunteer with those organisations under the age of 16. If there is confusion, let's listen to their feedback and let's respond to it positively with clarification. It's far from me to want to create further confusion, and in that vein, if the Minister is happy to work with all members, including myself on this, before we get to stage 3, we can ensure that some progress has been made in providing reassurance to the organisations who asked me to move these amendments. On that basis, Convener, I withdraw them.
Thank you very much. So the question is that section 71 be agreed. Are we all agreed? Thank you. The next area is PVG Act participation of persons aged 12 to 15 in the scheme. And I call Amendment 127 in the name of the Minister, grouped with amendments as shown in the groupings. And I invite the Minister to move Amendment 127 and speak to all the other amendments of the group.
Thank you, Convener. In the written evidence to the committee, the Scottish Social Services Council highlighted their need to be notified about any change to a member's status in the PVG scheme. I'm pleased to move a number of amendments which ensure that regulatory bodies are notified when a scheme member's membership is due to lapse and where they have failed to renew membership. In reviewing these provisions, I'm also moving amendments which will further enhance safeguarding for individuals who employ PVG scheme members within the context of personal arrangements where an organisation is not involved. For example, an individual who is arranging their own personal care through self-directed support and employs a PVG scheme member to carry out a regulated role for them. These amendments allow ministers to notify individuals of these changes to the membership status of their employee. I move Amendment 127.
Thank you. Do any members wish to make comment? No. Can I, Minister, do you wish to wind up? No, thank you. The question is that Amendment 127 be agreed. Are we all agreed? Yes. Thank you. I call Amendments 128 to 134 in the name of the Minister and all previously debated, and invite the Minister to move Amendments 128 to 134 en bloc. Moved en bloc. Does any member object to a single question being put on these amendments 128 to 134? If no, the question is that Amendments 128 to 134 are agreed to. Are we all agreed? Thank you. The question is that section 72 be agreed. Are we all agreed? Thank you. I call Amendments 135 to 145 in the name of the Minister and all previously debated. I invite the Minister to move Amendments 135 to 145 en bloc. Moved en bloc. Does any member object to a single question being put on Amendments 135 to 145? The question is that Amendments 135 to 145 are agreed. Are we all agreed? Yes. Thank you. The question is that section 73 be agreed. Are we all agreed? Yes. Thank you. I call Amendment 146 in the name of the Minister, already debated with Amendment 36, and invite the Minister to move formally. Moved. Thank you. The question is that Amendment 146 be agreed. Are we all agreed? I call Amendment 147 in the name of the Minister, already debated with Amendment 36. Invite the Minister to move. Moved. Thank you. The question is that Amendment 147 be agreed. Are we all agreed? Thank you. I call Amendment 211 in the name of Jamie Green and invite him to move or not move.
Not moved.
Thank you. I call Amendment 212 in the name of Jamie Green and invite Mr Green to move or not move.
Not moved.
I call Amendment 148 in the name of the Minister, already debated with Amendment 36, and ask the Minister to move. Moved. The question is that Amendment 148 be agreed. Are we all agreed? I call Amendment 149 in the name of the Minister, already debated with Amendment 36, and invite the Minister to move. Move. The question is that Amendment 149 be agreed. Are we all agreed? The question is that Section 74 be agreed. Are we all agreed? And the question is that Section 75 be agreed. Are we all agreed? Thank you. We now move to regulated roles with children or adults, elected representatives and political activities. I call Amendment 222 in the name of Alex Cole-Hamilton, grouped with amendments as shown in the groupings, and invite Mr Cole-Hamilton to move Amendment 222 and speak to all the amendments in the group.
Thank you very much, Convener. I'm very grateful for the opportunity to be here today to speak to Amendments 222 to 231, which I move in my name. Before I start, I'm aware that some discussions have been had about my motives for bringing these amendments to committee today. And I assure you it's not about showboating, it's not about virtue signalling, nor is it about seeking to weaponize the process to embarrass political parties to vote one way or the other. It comes from a very deeply held belief in child protection after working in children's services, children's rights and child protection for 13 years before my election to this place. I was heavily involved in the consideration of the original Protection of Vulnerable Groups Act in 2007. I was recruited to the government's Voluntary Sector Issues Unit, which met over the course of 8 months to ascertain the practicalities of implementation of the new scheme as it rolled out. This was a loophole I identified then, that politicians get an exemption. And I raised it then, but we were unable to close the political gap, to change that at the time. So this is an opportunity, I think, to right that wrong. If you permit me, Convener, I'd like to open my remarks with specific reference to the policy memorandum, which states the Scottish ministers consider that roles for which PVG membership is a mandatory requirement should have at their core the capacity or opportunity to exert significant power or influence over a child or protected adult. I agree, which is why when this bill was first introduced to Parliament in June 2019, I asked whether the government would extend the provisions of the bill to elected representatives. The minister will remember that she answered my question with some positivity and suggested that she would be happy to assess whether parliamentarians fell into that category. My task today, Convener, is to persuade you that they do. Politicians, whether they are elected or in senior party positions, have the capacity to change lives. They can offer help and solve sometimes intimate problems through casework. They dispense patronage and through employment and mentorship, and they can offer school children work placements unlike any other. In today's personality-driven culture, politicians can sometimes feel like celebrities. There is no question that they have both power and influence. The recognition of that power and influence is almost universal outside of this Parliament. So it's unsurprising that with that recognition comes a basic assumption that the PVG scheme already applies to politicians. That assumption turns to astonishment when people learn that politicians are exempted. One Edinburgh teacher said recently, the fact you have received several thousand votes isn't any sort of guarantee of somebody's suitability to be alone or in the presence of vulnerable people. Given the protections that are rightly in place for teachers and others, that nothing should apply to powerful people who encounter those same young people is a double standard and has the potential for serious abuse. Now, I know that many elected members take steps to ensure that they are never alone with a vulnerable constituent or a child, and that is to be commended. But there is no requirement for them to take such steps. It is conceivable that an MSP might be alone with a protected adult, for example, if that adult specifically asks for a private meeting, or there's a home visit where a staff member is just suddenly unable to attend. Life gets in the way. An MSP could also find themselves alone with a young person on work experience, driving them around the constituency. This might not be considered good practice, and certainly it exposes that MSP or elected member to risk, but nowhere are they prohibited from doing so. And Convener, my central point is that because politicians have both influence and access should they wish to have it, then they are at liberty to do so unencumbered of safeguarding of any kind. Put simply, we are trusting that because an individual has persuaded a body of people to elect them to office, that their intentions and their conduct will be assured. I'm sorry, but I can't accept that that is sufficient. PVG checks, as we know and this committee has heard throughout stage one, are not a silver bullet. They don't flag everyone who needs to be flagged, and they offer only one layer of safeguarding, but it is an important one. The first draft of my amendment simply sought to remove the exemption for elected representatives, and the government rightly pointed out the grave constitutional implications of making the entirety of an elected position a regulated role. That should a sitting MSP, for example, fail a PVG check, then a minister could theoretically unseat that MSP. So my Amendment 224 seeks to regulate one very particular aspect of the work of elected representatives, and one alone, and that's the occasions when they might have cause to be alone and unsupervised with children or vulnerable adults. Convener, there is widespread precedent for elected representatives being put through PVG checks in recognition of certain aspects of their role. Local authorities currently require a PVG check of those councillors sitting on children and families committees because of their likelihood they may inspect children's homes and have other unsupervised contact in that regard. It is for that small but conceivable function of the role of an elected member that 224 applies and explicitly states that it is limited to this kind of engagement. Should a sitting elected representative fail a PVG check and be found to have been barred from working with children or vulnerable adults, then Amendment 226, paragraph 32A and 32B, give ministers the power to work with elected institutions to build procedures so that they cannot undertake that specific kind of regulated work on an unsupervised basis. They would continue to be an MSP, could continue to meet every person they would have done with or without a PVG. However, safeguards and protections would be in place. I will.
Can I thank Mr Cole-Hamilton? Sorry,
I'll let you come in later on, but we don't
That's
move
fine.
into
Do it that way.
interventions in
Okay,
this part
fine.
of the debate. Thank you, Mr.
Okay.
Thanks.
I'm happy to come back to you later, Jamie. Something that doesn't exist at present. I can't understand why we wouldn't want to have that level of reassurance. PVG sets a standard, and if you don't meet that standard, then provision needs to be made around you to protect those who need to be safeguarded. As with any other area of work, the knowledge that background checks reveal would be wholly restricted. PVG is rooted in privacy. The electorate or media wouldn't know and wouldn't have the right to know. Under data protection laws, only the managing organisation is entitled to this information. However, the electorate and the media would at least have the knowledge that if someone didn't have a PVG, that they wouldn't be allowed to be alone with children, and safeguarding provision would be put in place. They can have no such confidence or reassurance of that at the moment. Convener, my amendments cover every level of elected office in Scotland. The Scottish Government contend that this rides up against the Scotland Act, insofar as it places requirements on Scottish MPs. To those concerns, I would say this. Child protection is entirely devolved. If we don't feel we can put the same safeguarding requirements on Scottish MPs, then no other democratic institution is empowered to do it for us. MPs do not have diplomatic immunity in Scotland, and when operating in Scotland, they have to abide by every law passed by this Parliament. I'd like now to turn to Amendments 225 and 227, which stretch these provisions to positions of responsibility within political parties. These amendments are self-contained and stand alone. And right now, it is an offence for a political party to ask for a PVG for anyone who is not undertaking regulated work as it is currently defined. But we know how things can be. A target seat candidate is at the centre of everyone's attention for the 7 or 8 weeks of an election campaign. And they may end up working long into the evening in campaign offices with a range of volunteers who might fall into either category. Influence in politics can be magnetic, and we need to recognise the combination of influence and access wherever it may exist. A PVG check is not a barrier or a bar to a candidacy, but it would help political parties make better informed decisions about allowing candidacies to progress along with other safe recruitment practices. Everything in my amendments have been drafted to stay within the devolved competency of child protection and the protection of vulnerable adults, and they exist primarily to change the culture of expectation around the checks that people may now have to undertake in pursuit of a political career. Some have expressed that this might present a barrier to those seeking election, that a PVG costs money. That is certainly true, and I agree with the principle that there should not be a financial impediment to standing for election. But there shouldn't be, but that can be sorted through regulations. There is precedent for fees to be waived. Take, for example, the Volunteer Scotland Disclosure Services. We could define political activity as a public service, and there are straightforward ways this could be arranged. Convener, we all need to learn the lessons of the independent inquiry into child sex abuse. There are painful lessons for every party, my own party included, and a multitude of institutions. The IICSA warned about putting reputation above child protection and what can happen when there isn't robust safeguarding. Indeed, if you're going to take anything from that inquiry, anything at all, it is a recognition of the aura that politicians can carry, the deference to them that can occur, the assumptions that people make about their probity, and the idea that they will self-police. To assume that election to office is the only safeguarding we need is an attitude that will unquestionably put our children in danger. And it is an attitude that history has shown us opens the door of politics to people who are determined to abuse others. It is time to shut that door. We've made huge progress in recent years towards creating a safeguarding culture in every other workplace and sector. Many are significantly better than they once were. So why are elected politicians exempt from that process of improvement? Because history and inquiries show that they should not be. Voting against this today would send an awful message to every profession and sector that is working diligently and putting safeguarding at the centre of everything they do. If you have concerns about the structure of these amendments, then I am happy to work with the committee to tighten up this legislation, to offer reassurance about how it will work. But it has been over a decade since we last updated disclosure law, and the risk of that by putting nothing in this bill at stage 2, the window for getting something in the bill at stage 3 reduces massively. It may be another decade before we look at this again, and to miss this opportunity would be to fail to amend this bill, would be to extend the exemptions that politicians currently enjoy unencumbered by safeguarding. We are talking about a simple check that already applies to over 1 million people in Scotland, a simple check that would trigger straightforward safeguards if necessary. Convener, this is a gaping loophole, and it is one that we must close.
Thank you, Mr Cole-Hamilton. Can I invite Ms Ross?
Thank you, Convener, and I would also like to thank Alex Cole-Hamilton for bringing this extremely important topic to our discussions today. And I'm just going to start off by saying the fact that Mr Cole-Hamilton has spent so much time talking about these amendments tells us about the gravity of the situation here. I think that this is far too big an issue for our committee to be dealing with. We've taken no evidence on it. Quite frankly, I think that we need to spend, if we were going to do this, we would need to spend a lot more time on it. I think that this is an issue for the whole Parliament to discuss.
Was the member taking intervention?
Absolutely.
I'm grateful to Gail.
Mr Cole-Hamilton, sorry, we're not going to have intervention. We've got, you will have an opportunity to sum up at the end. Okay. Ms Ross, you've
yeah, I mean, I absolutely agree that it is an anomaly that people in positions such as ours with the power and responsibility that we have are not PVG or some other disclosure checked. But I think from listening to what Mr Cole-Hamilton had to say, I'm not any clearer on how it would actually work in practice. He spoke about the way that it works in local councils, and it pertains to members that sit on specific committees that may have to deal with vulnerable groups. But he also says that in an MSP's position, and I don't think I do agree that, certainly from my own point of view, would never put myself in a position where I was going to be alone with a child or a vulnerable person in that way. I would always make sure that there is someone else. And, you know, if life does get in the way, as he said, then I'm sorry, but there has to be some adjustment to make sure that, you know, that never does happen. So I absolutely sympathise with the intention behind this, but the fact that we really need to go into this a lot deeper, and I do think that it's probably a standards issue and something for the whole Parliament to discuss rather than us here one day for half an hour.
Thank you, Ms Ross. Mr Green, do you want?
Thank you, and apologies for the confusion on the proceedings. Just to make a few points, and I'll ask them as questions to Mr Cole-Hamilton, and he can perhaps respond in his summing up. Would these checks take place before, during or after election periods? And what would happen in the case of, as we've seen in the last few years, numerous snap elections which may or may not take place? Would it apply to only candidates who are standing in Scottish seats, even if they are members of other institutions? Would it apply to English elected MPs who are working in Scotland temporarily or otherwise? What would be the scenario where if a member of any elected body refused a PVG check at any point, would they be committing an offence? If they failed the PVG check, how would that affect their ability to carry on their duties? The member said that they could not be unseated, but they would be restricted in doing certain types of roles without adjustments or without being supervised. I see some huge gaping holes in that analysis, Mr. Cole-Hamilton. Again, I ask these questions in a positive light because I think, like Gail Ross, there is a lot to be said for the member's approach to this, and it's certainly quite obvious long-standing interest in the subject, and it's something that we do all share, but it does look and feel to me like a much bigger issue that will have ramifications outside of this room and indeed perhaps this Parliament, and that's something that to give it full justice should go through due process of scrutiny. And again, that's something I simply don't think we may have time to do in the short period we have at the stage 2 proceedings. So I'll leave my comments at that. Thank you.
Okay, thank you, Mr. I've got a number of committee members wanting to come in. Mr. Johnson.
Thank you, Convener. Mr. Cole-Hamilton began by raising the question of his motives, and I don't question those for a moment. I think Mr. Cole-Hamilton's commitment to child protection and children's issues are beyond question. Nor do I think he should be questioned or criticised for his attempt to shift the boundaries of what we attempt to do, both with this piece of legislation, but generally with the legislative process. I think he is absolutely right that we have to make sure that we have the highest levels of scrutiny and protection with regard to roles where people have the opportunity to exert control and influence over children and young people. However, there were a number of things he stated about the nature of our role, which I would question, and indeed I think are questionable, and indeed I would say dangerous to state. He stated that by virtue of our roles as MSPs, that we gain unsupervised access to children. Access, should we wish to have it, was, I think, a phrase that he used. I would categorically state that that is incorrect. Anyone that thinks that by virtue of being an MSP that you have a right or indeed an expectation to have unsupervised access to children is categorically wrong, and is actually quite a dangerous assertion to make. And indeed, I think that is what we should be looking at, is what is a kind of an appropriate way for us to do our business. And I don't think that we should be conducting our business in such a way that requires that supervised access. And a bit along the lines of the comments I raised with Mr. Green's amendments, I think we need to look at the way that this bill seeks to operate and the way it conceives of what and when you are required to have a PVG. And this is what it is sought to do, is rationalise this around roles, and I think that is correct. What we want to do is not have a situation where PVGs are required whenever one may just happen to have fleeting contact with children. No, what it seeks to do is structure this around situations where someone has necessary and unavoidable unsupervised contact with children, or the ability to manage and administer the systems around which that takes place. I do not believe that is a situation which pertains to being an MSP. What is more, I don't think that it is advisable to do so. When I think about my own practice, whether you're talking about a child or a vulnerable adult, I would say that it is always important, and actually I would challenge a comment that both Mr. Cole-Hamilton and other members have made. I don't think it's sufficient simply to have a staff member present. You need a person that has responsible caring duties to that individual present, both for practical and communication purposes. In the situation of either a vulnerable adult or a child, I think it is important, if you have a surgery meeting with that individual, that a responsible carer is present, so that you can confirm that your understandings from that case are the ones that were intended to be communicated. That is not always straightforward. I think, so therefore, before we even get into the situation of whether it is appropriate to have unsupervised access, I do not think it is sensible or a good way in order to take that information or that communication. But I also think that it is not sensible and not appropriate for us to do so. And I would also say that in this regard, our role is actually quite substantially different to those of councillors who may require PVGs. And that is because they require those roles not by virtue of their roles as elected representatives or the fact that they may hold surgeries such as we do. It is because they are responsible for administering many of the institutions, organisers, systems, schemes around social work, education and other systems which have direct responsibility for looking after, caring and supervising children within local authority areas. That makes that role quite substantially different to the one that we carry out. Ultimately, we also need to look at what a PVG is for. And it's there in order to inform employers and those organising and supervision of children. It is not there as a system of vetoes or debarring people. It is there to provide relevant information to those people administering those systems. In this situation, I can't understand where this information would go to allow someone to make that sort of informed choice. We have an odd and unusual set. We do not have a boss. We are not employed in that sense. We do not have an employer or a manager who can take a PVG and decide how and when our role can be structured in such a way. It would therefore be used as a veto in precisely the way that I don't think that we want PVGs to work. A PVG I think it is dangerous if we use a PVG as a sort of a quote-unquote passport to have access to vulnerable people. I think using it in these circumstances and in this way runs the risk of doing exactly that. What is more, given that this is administered formally by government, we would be placing ministers in an invidious position of presiding over and having access to information, not just provided in the PVG, but also information that is not included in the PVG on fellow elected representatives. I think that has very serious constitutional implications, and one that I do not think that we should take lightly. Furthermore, I have spoken to a number of organisations directly interested in these matters and who have provided evidence to the committee through the passage of the bill, who agree with me that while the motivations are ones that are worthy and understandable, that the consequences and other considerations are so serious that they have significant concerns. Moreover, what I would say is this: I do not think it is appropriate for us to either expect or let alone carry out unsupervised contact in this way. I think the thought that somehow we do is one, if it exists, that should be challenged, and I think this is a matter for standards. I would strongly suggest that if there's any question of this, that should be put into the Code of Conduct for MSPs, that we are not to have unsupervised contact with vulnerable people. The one final thing I'd say is this. Mr. Cole-Hamilton mentioned the example of work experience. This is the one other situation where conceivably such contact could arrive at. Unfortunately, within this bill, work, whether it is paid or unpaid, is excluded from these provisions. Now, I think there is a bigger question about whether or not work experience should have some sort of further consideration. But the consequences and implication of requiring all people who have work experience, people doing work experience in their businesses or organisations need to be or would be required to have PVG checks is again one which has consequences, I think, far beyond the scope of which we've taken evidence for or have considered. So, with regret, for those reasons, I don't think that these amendments are supportable at this time.
Thank you, Mr. Johnson. Ms. Mackay.
Thank you, Convener. Yeah, much of what I was going to say has really been covered by all my colleagues. Just want to say I support what they've said. I agree with it. There's just one thing I wanted to add. Mr. Cole-Hamilton said he thought this would be a lost opportunity for perhaps a decade. I don't believe that would be the case, and I wonder if the Minister, in her summing up, could clarify that won't be the case. Thank you.
Okay, Mr Neil?
Yeah, I think we've got almost a consensus on this amongst the members of the committee. Can I first of all just say, like others, I do not question the sincerity or motivation of Alec Cole-Hamilton. I know he's got a long background in this area of activity, and it's quite right that he airs his concerns. But I think there are 2 or 3 points I would make. First of all, I think this is alien to the purpose of the bill and the original legislation. This is not about, I mean, if there's a case for having elected members registered, there's almost a case for having the whole population actually registered amongst on the PVG register. And I think that would totally dilute and divert resources away from the areas where we need to focus in resources. So I think it's contrary to what the main purpose of the legislation is. Secondly, I think if you put this in primary legislation, there's a real danger that it becomes a political football for people to kick, not just even against their political opponents, but perhaps even people in their own party. And I think there's a real danger of that, and that again would do no service to children or other vulnerable people. And the third point, just picking up on Daniel Johnson's point, is I think it is fair for us to ask the Standards Committee to review the Code of Conduct for MSPs and establish whether there is any need to amend or add to the Code of Conduct. And remember, the Code of Conduct at the end of the day is legally enforceable, and we're all subject to the law. And at the end of the day, if we do anything untoward, or even are suspected of doing anything untoward towards, for example, children and other vulnerable people, then the law can take care of that, and I'm absolutely sure it would. So while I totally respect the motivation and the sincerity of Alec Cole-Hamilton in this, I do think it's the wrong way to tackle what might become hopefully an isolated incident. And to the best of my knowledge, in 21 years in this place, no issue has arisen of this nature, but that's not to say it could not in the future. But that's a matter for the Standards Committee to look at in terms of reviewing the Code of Conduct and make sure that any loopholes in this respect are addressed. I think that would be a proportionate way to deal with the issue rather than putting it in the face of this bill.
Okay. Mr Greer?
Thank you, Convener. Like colleagues, I respect the work that Mr Cole-Hamilton has put into this. I am a PVG scheme member, and like Mr Cole-Hamilton, I've undergone safeguarding training for the purposes of youth work. So I appreciate what he's trying to achieve here. And I don't want to repeat points that colleagues have made, because I think there is a point of consensus on the committee. There are a couple of issues that I think are worth raising in addition, though. The very short debate that's been had on this so far has essentially conflated the role of all elected representatives. But these are all very distinctly separate roles. And the issue of MPs and competence to legislate in that matter has already been touched on. But I would just like to distinguish between the role of an MSP and that of a councillor. The Parliament doesn't run schools, we don't run care homes, we are not responsible for the inspection of facilities like that. That's not to say that for that reason alone, MSPs should not be required to undergo something like a PVG check. But it comes back to the core point that's been made by a number of members here. This is an incredibly complicated debate with significant repercussions, and we've simply not had the opportunity to explore all of these issues sufficiently. So I appreciate what Mr Cole-Hamilton's trying to do. I've had concerns raised with me by staff about this, about what the implications might be for MSP staff. Again, these are issues that I think could potentially be teased out and thrashed out. The issues that were raised were, for example, of staff feeling that there might then be additional responsibility or expectation put on them, or would additional resource be deployed in a situation where an MSP were to fail a PVG check? If additional resource is deployed, how can you possibly keep that confidential in the kind of public environment that we work in? These are all questions that may have entirely satisfactory answers. this is not a setting in which we can satisfactorily thrash all of that out. So I would urge Mr Cole-Hamilton, if he does want to pursue this, not to press it now, and to work with, I would be particularly interested in getting the position on this of Children's Commissioner, the Law Society, Clan Child Law, but also for this to be a much wider debate for Parliament and for our public institutions as a whole. I think that we should always, despite what I've said about a commitment to thorough safeguarding procedures, we should always be instinctively sceptical of anything that would create a barrier to elected office, even if it was a cultural barrier that came about not as an intended but as an unintended consequence of a very valiant effort such as this. So as I said, I would urge Mr Cole-Hamilton not to press these amendments today.
Thank you. Mr Gray.
Convener, I agree with the comments that colleagues have made around the application of the PVG scheme to elected members, so I don't want to exercise those same arguments again, but I did want to focus for a moment on the amendments which extend that requirement into political activities. Gail Ross, in the first contribution in the debate, made the point that these amendments, the principle seems fairly straightforward and worthy, but the more you examine them, the greater the consequences which flow from them are, and therefore they need very careful consideration, consideration which we're not going to be able to make properly at this stage. So I just wanted to ask Mr Cole-Hamilton 3 questions around the development of these amendments particularly. One is, what consultation has he undertaken with councillors, COSLA, MPs, MSPs, the Electoral Commission, all those bodies who would have an interest in a requirement being placed on candidates? Secondly, how would his proposed system operate for those who stand for election as independents, not as a member of a political party? I know that's relatively unusual in parliamentary terms, but of course there are local authorities where almost all the contests are between independents. And thirdly, around this issue of competence, I appreciate Mr Cole-Hamilton has said that in his view, this is a child protection matter and that's devolved. But it seems to me there's a very strong counter-argument which says these amendments place a requirement on candidates in UK elections over which we do not have competence. So I would ask what independent legal advice he's got to support the position that he's put to us today.
Ms Smith.
Thank you, Convener. And can I put on the record my thanks to Alex Cole-Hamilton, who I believe is pursuing this with the best interests in mind. I've sat on this committee at the time in 2008, 2009, when I remember as a witness, I think at the time, you were providing us with some information about that. And I do understand where you're coming from. My concerns relate to the responsibility and, by definition, the accountability of where both a parliament would stand and where a political party would stand. And I cite my own role, which I've only been in the job for 3 weeks as Chief Whip, but I can see a lot of contradictions and concerns, and perhaps a conflict of interest, actually, between the role that the Parliament would have and the role that a political party would have with respect to who was responsible for making a decision about the PVG and how that information would be passed from one to the other, because I can foresee a lot of difficulties with that. And I would agree with Ian Gray when he says that, you know, I think it would be incumbent upon us all to ensure that the legal advice, I'm not sure if you have taken legal advice, not specifically with the Children's Commissioner or the actual specific legal advice as to how this would work, because I'm not convinced that your proposals are workable. And I think the issues for me are about the responsibility that somebody would have to take about the PVG and any information that was forthcoming from that PVG, especially should that person not live up to the standard and fail the test. Does that come down to the political party, who is responsible in most political parties for deciding whether we are fit to stand for office? Or is that a decision for the Parliament to then report to the political party? I think there's a lot of really complex tensions there. And I agree with the points that have been made about the fact that I think the amendments as they stand do have implications for MPs and for other jurisdictions. And that's why I think, well, I'm not in a voting position, obviously, but I have grave reservations about just the workability of this. I think they're quite serious concerns that I think could make the working of this Parliament more complex than it need be, and raise a lot of issues about how it relates to a political party. That's my big concern. Okay, thank you, Convener.
Okay. Just before I move to the Minister, I would like to say myself that, and it's because of a specific example Mr Cole-Hamilton gave about travelling with someone on work experience. My own local authority guidelines would make that impossible if I follow them as an MSP, because it's specifically instructed not to be alone with a young person on work experience. And I just highlight that as an example again of there's a lot of work to be done. We need to be working with COSLA and other organisations to absolutely get this right. And I thank him for bringing the issue to the committee. I would now like to invite the Minister to comment.
Thank you, Convener. These amendments are well-intentioned in their aim, and I thank Alec Cole-Hamilton for raising this important issue. I've listened very carefully to the debate, and I'm grateful for the opportunity to explain the Scottish Government's position. These amendments present a number of challenges which will have very significant constitutional implications. They've not been subject to consultation with the public or with Parliament, and I firmly believe that it would be better if the member were to raise this with the Standards Committee or even with the presiding officer, so that they, on behalf of the Parliament, can look at this issue. And I'm absolutely prepared to work with Parliament to find a solution, but I do not think that the provisions of this bill are the appropriate way to do this. Criminal record checks are a vital tool to support and to inform recruitment. And for that reason, I am sympathetic to the rationale behind calls for elected representatives in the PVG scheme. I think it is important to remember that the scheme is specifically for those working with vulnerable groups, and there is no pass or fail to disclosure. The presence of disclosure information does not automatically mean that somebody is unsuitable to work with children and protected adults. Committee members will be aware that there are non-PVG Level 2 disclosures as well, and in broad terms, the other forms of Level 2 disclosure offer the same disclosure information as the PVG equivalent. However, they do not bring into the scheme people into the scheme which requires ministers to bar an unsuitable person from regulated roles. Non-PVG Level 2 disclosures are used for judicial appointments, for instance. If there's a desire within the Parliament to allow an identified body to have access to non-PVG Level 2 disclosures for elected representatives, I'm open to discussing how that can be implemented. To achieve it, we would in all likelihood change the Rehabilitation of Offenders Act 1974, Exclusions and Exceptions Order, Scotland 2013, to cover elected representatives. This can be done through secondary legislation instead of the bill, but would really require very careful consideration about who would be appropriate to receive a disclosure and make decisions about the suitability of elected representatives to hold office. As I've previously said, criminal record checks can only be one aspect of safeguarding, and no organisation should ever be solely reliant on them in protecting vulnerable people. I agree with Mr Cole-Hamilton that there are very painful lessons to be learned from the independent inquiry into child sexual abuse, and I think it's worthwhile that we take a moment to reflect on the lessons that we have learned from the case of Cyril Smith MP. That case clearly illustrates an inadequate institutional response to allegations of child abuse, and as such shows us precisely, I think, the kind of problem that the member is trying to solve. Now, Cyril Smith was never convicted in his lifetime, but allegations of child abuse, including reports to the police, were made against him over 4 decades. It is possible that a criminal record check would have contained ORI relating to that. It is also possible that it would not. What is very clear when we reflect on his case is that safeguarding children is about more than a criminal record check, much more than a criminal record check. It is everyone's responsibility to protect children. So a key part of safeguarding is about recognising and responding to allegations of abuse. What are the responsibilities of all of us when allegations are made? In Cyril Smith's case, clearly those around him did not feel it was their responsibility to respond to allegations. It is not at all clear that a criminal record check would have protected children in this case. A different response from those to whom allegations were made would have protected children. That is why I would advocate a much more holistic response to this problem than just a criminal record check. I agree with the members who have said that in most situations it's best practice to have at least 2 adults present when you're working with children and young people. I agree, I would question whether there is ever any real need for children to be unsupervised with an elected representative, and I would advocate that we work together as a parliament to ensure that safer working practices are in place to avoid this. Turning to Mr. Cole-Hamilton's amendments, he has said that he wants all elected representatives in Scotland to be subject to a PVG check and membership. These amendments also seek to bring those who hold positions of responsibility in political parties into the PVG scheme. In terms of elected representatives, the amendments will not achieve this aim. I say this because they will not bring all elected representatives into the PVG scheme in relation to both the children's and adults' workforces. In relation to children, some elected representatives may never carry out activities which are described in the new paragraph 30A, and they could organise their constituency and other business so as not to have unsupervised contact with children. Many of us have stated that that's what we currently do. Even if they did have some contact with children, the elected member must take steps to ensure that the session or event was always in the presence of a responsible person, meaning that the child would not be unsupervised. And, you know, if contact with the child was not unsupervised, Amendment 222 means the activity is not within the scope of the PVG scheme. Similarly, the amendments will not have the effect of bringing all elected representatives into the PVG scheme in relation to carrying out regulated roles with adults. Again, it is entirely possible that the elected representative will never be engaged in the activity described because they may choose not to run sessions or events involving protected adults. There could even be the completely unacceptable risk of protected adults having fewer opportunities to engage with their elected representatives, for instance, by being excluded from events if elected representatives were not scheme members and were concerned about the implications of inviting them. There's also the question of how the elected representative would know if any given session or event included a protected adult, since the definition relies primarily on private and intangible characteristics. With Amendments 226 and 229, Alec Cole-Hamilton appears to recognise that there are constitutional problems with his proposals. They propose that ministers should make regulations to disapply the offence provisions in regards to elected representatives, so that the amendments could apply effectively to elected representatives. I have noted, though, those amendments do not extend to political activities, meaning, for example, that a decision by Scottish ministers exercising their barring functions under the PVG Act could in effect prevent a barred individual from standing as a candidate for election in the first place. The committee should note the existing powers in the PVG Act to disapply the offence provisions for particular types of regulated work have only been used once before. In this case, there are regulations which disapply the offence provisions in the context of permanence orders so that an administrative decision by Disclosure Scotland's Protection Unit on behalf of Scottish ministers cannot override a court decision made in the best interests of a particular child by listing an individual who also happens to be a foster carer of a child on a permanence order. That's to avoid the individual and the council committing a serious offence by following the order of the court and allowing the child to remain with the individual beyond the date of the listing decision. This exception was clearly for a very particular situation which is entirely different to the proposed approach for elected officials. The amendment neither delivers PVG membership for all elected members as a certainty, nor necessarily covers the activities that a member might undertake with children, simply dependent on whether they are unsupervised doing them, meaning it would be ambiguous for an elected representative as to whether they were required to join the PVG scheme and in relation to which workforce. Disapplying the offence provisions removes the benefits of the barring arrangements under the PVG scheme. On that basis, there is no justification for requiring elected representatives to participate in the PVG scheme because all we are left with is the state issuing disclosure records. As I've said, if there is a desire within Parliament for non-PVG Level 2 disclosures to include representatives, I am open to discussing how this happens. Like other members, I am unclear to whom a disclosure should be made. The amendments make no comment on who would be an appropriate person to assess the suitability of MSPs for a regulated role. And there are also difficulties with regard to the public's understandable expectation of transparency around their elected representatives. The body who receive the information would not be able to share the disclosure information, including information about listed status, more widely. I invite Mr Cole-Hamilton not to press his amendments and to take this matter up with the Standards Committee. If pressed to a vote, I urge committee members to reject these amendments.
Thank you, Minister. Mr Cole-Hamilton.
Thank you, Convener. I've got quite a lot to unpack here. I've been asked a lot of questions, so forgive me if I take a bit of time. But I'll start by saying this. At the top of my remarks, I referred to my time on the Protection of Vulnerable Groups Voluntary Issues Unit, which was part of the implementation process of the bill. We met over 8 months on a weekly basis to iron out the kinks of the rollout of what was a considerable bureaucratic exercise, retrospective checking. I did so on that committee. There was a very charismatic chief executive of a voluntary sector organisation who was an expert in child protection. Halfway through the proceedings of that process, he was convicted as being part of one of Scotland's most egregious paedophile rings in history. Now, he wouldn't have been flagged by PVG, but I make that case because it shows that with status comes an assumption of probity. He could well have gone on to have a political career, and whilst PVG might not have caught him in that circumstance, PVG is a level of assurance and safeguarding that we currently do not have for any elected member. A number of people asked, in fact most people asked, about self-policing, about the fact that they would never put themselves in that situation. I understand that, I respect that, and I applaud them for that. It shows that they have safeguarding at the thought of their minds. But, Convener, we need to legislate, as politicians, we need to legislate for people as we may occasionally find them, not as we would wish them to be. And as such, we have to accept that there are politicians who won't have that probity, who won't have that desire for safeguarding because they may have nefarious intent. And we have heard examples of politicians who have been found wanting in that regard. Jamie Green asked several questions. He asked about, for example, snap elections. Our proposals would be, and the work we've discussed around this would be that this would form part of the regular vetting process that parties hopefully already employ for the selection of candidates, so that if you are to become a target seat candidate or any candidate in an election, that you go through a vetting process. And a PVG check would be much the same as joining a scout group or a Sunday school in as much as it formed part of the usual recruitment process of the selection. If we, in terms of the rollout, that is all open for discussion as to, and actually a lot of that could be swept up in that time. You asked about if it would only be Scottish seats. Yes, it would only be Scottish seats. We only have the power to legislate within Scotland, and it wouldn't apply to visiting MPs from other jurisdictions. Why? Because it's not reasonable to expect that they would have cause in the course of that visit to have unsupervised contact with either children or protected adults. If somebody refused a PVG, that's certainly possible. People may take umbrage at this, that they are being subjected to this manner of checks. I would hope that the culture would change to suggest that you know, this is just part of political life now. But if they did refuse, and then they went on to undertake regulated work as we have now defined it through my amendments, then they would be committing an offence and subject to the full force of the law. And if they failed a PVG check, there is a provision within my amendments to allow ministers to make arrangements with the democratic institutions. And this is an important point because several members have asked about this. We are not reinventing the wheel here. That it's quite clear, there are clear rules of engagement and strata within existing, sometimes large voluntary organisations as to who receives the information about a disclosure or barring certificate. In the Parliament, it would not be the presiding officer. The presiding officer is a member, just is one of our peers as members of the Scottish Parliament, but it would be the Chief Executive. It's the organ of the Scottish Parliament and work with SPCB, possibly the Standards Committee as well, to make provisions, should in the unlikely event that an MSP fail a check, that they be covered. Dan Johnson, so there's a range of things that Dan said. In terms of his remarks about a protected adult, I think it's important that we be careful here. The definition of a protected adult is a lot broader than you might think. And we don't, if you are a protected adult, you don't automatically have a communication support need. You don't even necessarily have a carer. I mean, somebody who has of advanced years, has comorbidities, a range of conditions, would be considered a vulnerable adult. There may be nobody else in their life, so it would not be appropriate to suggest that they would need to be supported by a carer or a representative to help with their communications. There is no guidance or when we're elected as to what rules of engagement we should employ in the normal course of our work, that we shouldn't be alone with people, or how, you know, whether we have doors open or doors closed and who sits by the door. None of that is really given to us as MSPs, or if it is, I've never probably seen it. We should have that. And there's no, but even so, even if there's guidance, there is no prohibition on the access that we can enjoy. We all have power in our offices. We can all say, listen, this is going to be a sensitive meeting. I think I should take this one alone. And our staff will demur to that because we know the culture in which we find ourselves. Alec Neil says that my amendments are alien to the purpose of the bill and that it, in a sense, would dilute it. That why he said, would, if we extend it to elected members, should we not then extend it to the whole of the population? And I simply say to him this, that the whole of the population do not have the power and influence that we as elected members have. And that's important. When people come to see us, they come to see us for a service. They want us to help them. They need us. Sometimes in abject desperation. Other members of the public never have that leverage over vulnerable individuals in that way. So I would reject that argument. He suggests, and Dan Johnson suggested, that this could be swept up in the Standards Committee or through the Code of Conduct. But I would say to them that the Code of Conduct only really matters after the fact. It only actually kicks in if we breach it. So if you are alone with somebody, or if you have some unscrupulous contact with them, it will only be swept up through the Code of Conduct if you breach it. The protection of vulnerable groups is there to ensure that people have an assurance and a confidence that the people that are serving them as their elected members have been through this check, that there is this one level of safeguarding. It is not foolproof, but it is there, and it is one more than we currently have. Ross Greer said that we don't run the difference between councillors and members, and that's entirely accurate. We don't run schools or children's homes, but we visit them regularly. And again, when we visit them, we do so with a bit of pageantry. There's quite a lot of excitement. And again, we're made to feel the centre of attention. We have an influence in the rooms that we visit. And I want to pick up on this point in terms of Ross Greer's comments. And many members have said that this is too big for this bill, that we haven't consulted on it. It isn't big. It closes a small loophole in the original act, which made an exemption for politicians and elected members. And I absolutely agree. If you want to take further evidence, then please do so. If you reject my amendments this morning, please open up evidence again between stage 2 and stage 3. I will write formally to the committee to ask that if this doesn't go through just now, as I rather suspect it won't. But I think you still have time. You still have parliamentary levers to take the evidence that you need to and to test this to get this right. But it is something we need to get right. And we don't want to put barriers up to election. I get that. But right now, this is a barrier that people believe exists and are really surprised and quite shocked that when they, as their sports coach or their Sunday school teacher, they have to get a PVG, they assume, understandably, that we would already have that process already. Okay, so Ian Gray asked me very specific questions. Well, I've done a range of consultation within my own party, speaking to council leaders, councillors, members and office bearers within the strata. I have not taken legal advice on this, but this comes from, well, other than the discussions I've had with parliamentary clerks, this comes from a good place. It comes from an experienced place of somebody who's undertaken work in this field for a good number of years. In terms of your question about independent candidates, again, there are loopholes and problems here, and I understand that. But if we define regulated work as being a specific criteria, which I've already done in the text of my amendments, then independent candidates who did not have a PBG and who undertook that work would also be committing an offence and subject to the full force of the law. There would become an expectation very quickly, I'm quite certain, if everybody else is going through a PVG check, that it becomes the norm. And people, even if they're running as an independent, will expect reasonably, and perhaps even with guidance from returning officers, to undertake that as well. But I accept that there is a question mark on that one. In terms of competence, again, a number of people have asked about this, and I say again, MPs, Scottish MPs operating in Scotland do not have diplomatic immunity. If we say as a parliament that we cannot impose a requirement for Scottish MPs to have PVG checks, then they forever shall have no PVG checks because nobody else is empowered to insist it of them. You can't, as a House of Commons, insist on child protection measures that are different from the ones that we have in Scotland. They can't insist on it for their MPs. It would be an offence right now because we have not defined their activities as regulated work in a Scottish context. And as I say, we are not reinventing the wheel, so I don't believe this is as complex as people have suggested. Finally, to the Minister's points, again, she said it almost sounded like this has come out of the blue. There's been no consultation. Yet I raised this in full Parliament in June 2019. I have raised it subsequently at the turn of the year as we started to get into the consideration around the drafting of amendments to this bill. She brought up Cyril Smith. I understand why she did. And of course, this, as I said in the top of my remarks, affects every party. My party more than most on that basis. But he wouldn't have been caught by PVG. But PVG is one more layer than we have right now. And again, other relevant information might have tipped the authorities within his political party that he was an unfit person to field as a candidate. She also asked what happens if you had accidental unsupervised contact, if you didn't have a reason to believe that there was a protected adult or child, and suddenly you found yourself in what we have defined as regulated work. Well, the bill already covers that, and there is a defence in section 74, paragraph 45C, which provides for exactly that. If you didn't have a reason to believe that you would be put into the proximity of either children or protected adult. Convener, in closing, I want to say I think it would be utterly indefensible in a few years if something had happened in a car park, in a constituency surgery, behind closed doors, in a council office, and there was prior evidence that the elected representative concerned posed a threat to vulnerable adults. If this Parliament says we don't need to do that check, a check which was raised a red flag to say that person shouldn't be alone with children or protected adults, it is hard to imagine the fury that would rain down on this place. We are talking about a simple check, and it is one, as I said in my previous remarks, that applies to over 1 million of our fellow countrymen and women, and I do not believe it should no longer apply to elected members in this place. I wish to press my amendments.
Thank you, Mr Cole-Hamilton. The question is that Amendment 222 be agreed. Are we all agreed? No. We move to a division. Can I ask those in favour of Amendment 222 to please raise their hands? Those against? And I see no abstentions. The Amendment 222 is not agreed. Thank you. Call Amendment 223 in the name of Alex Cole-Hamilton, already debated with Amendment 22. Mr Hamilton, to move or not?
Moved.
The question is that Amendment 223 be agreed. Are we all agreed? Move to a division. Those in favour of Amendment 223, please raise. Those against 223, sorry. Amendment 223 is not agreed. I'm going to call a suspension for 5 to 7 minutes at the moment, and then we'll continue with deliberations. Thank you. Welcome back to public session. We now move to regulated roles with children or adults miscellaneous. I call Amendment 150 in the name of the Minister, grouped with amendments as shown in the groupings. Point out that if Amendment 213 is agreed to, we cannot call Amendment 163 as a preemption, and if Amendment 217 is agreed to, I cannot call Amendment 180 as there is also preemption. So I ask the Minister to move Amendment 150 and speak to all the amendments in the group.
Thank you, Convener. One of the key reforms made by the bill to the PVG scheme is to replace the concept of regulated work as the eligibility criteria for scheme membership with regulated roles as a trigger for mandatory membership of the PVG scheme. The shift to regulated roles addresses the complexity within the current system and offers certainty about who needs to be in the scheme. It also contributes to the aim of refocusing the scheme on roles which give the post holder the opportunity to exert power or influence over children or protected adults. These amendments have been lodged to ensure Schedules 3 and 4 of the bill are appropriately scoped, drawing people into the PVG scheme when it is necessary and appropriate. In the main, the same amendments have been lodged for both schedules. To avoid repetition, I will discuss the amendments that occur first in the group, which are mostly in relation to Schedule 3 for children, and then highlight the corresponding amendments that relate to Schedule 4 for adults. Amendments 150 to 154 narrow the scope of the exceptions to regulated roles with children in the course of a personal relationship. In the bill as introduced, there is an exclusion for activities carried out in the course of a family or personal relationship. That would mean that a friend providing paid adult personal care services to another friend would not have to be in the scheme. This is wider than the existing exclusions in the PVG Act, which require there to be no commercial benefit for the family or personal relationship exclusion to apply. These amendments ensure the provisions are consistent with the existing exceptions under the PVG Act, preventing a potential gap that could be exploited to circumvent the mandatory PVG scheme. Amendments 164 to 170 make the same adjustments to the exceptions for regulated roles with adults. As I mentioned at the outset, a key driver of the shift from regulated work to regulator roles is drawing into the PVG scheme those roles where power or influence is exercised over vulnerable groups. Amendment 155 to 157 and 171 to 173 insert a definition of exercising power or influence over children or protected adults onto the face of the bill. This definition is inserted into the meaning of contact in place of existing references to making decisions that affect children and will make it easier to identify in conjunction with the activities in Schedule 3 and 4 of the bill whether a role is within the scope of the scheme. Amendment 158 removes the word employability and references to health or well-being from paragraph 11 of Schedule 3 and inserts the word education. This refocuses the activities in paragraph 11 onto those that are more relevant to services for children. This will ensure that we do not inadvertently bring job centre staff into the PVG scheme. Amendment 174 amends Schedule 4 in a similar fashion in relation to protected adults. Amendment 159 removes exclusively from paragraph 20. The purpose of this is to ensure that where the premises listed are used by both vulnerable groups and non-vulnerable groups, then individuals carrying out domestic services within them would still need to join the scheme. Under the bill as introduced, it is only where the premises in paragraph 20 are used exclusively by children that an individual would be required to join the scheme. When they are used both by children and adults, an individual would not be required to participate in the scheme. Amendments 159 and 175 address this anomaly. Amendment 160 and 161 together modify paragraph 24, removing support services and replacing it with a reference to advice or guidance in relation to health or well-being, to prevent against a wide interpretation of paragraph 24, drawing administrative or backroom staff into the mandatory scheme. Amendments 177 and 178 make the same adjustment in Schedule 4. To address a similar scoping concern around administrative staff, Amendments 162 and 163 amend Schedule 3 and Amendments 179 and 180 amend Schedule 4 to the more direct language of providing the various types of activities and services described. This will ensure that regulated roles are those directly involved with children and protected adults rather than people making administrative arrangements to allow those activities to take place. At present, it could be argued that contact includes written communication if people in such administrative roles send letters to children or protected adults. These amendments will avoid drawing such roles into the scheme where it is not necessary or appropriate. I now turn to amendments 213, 214, 217 and 218. I thank Alistair Allen for bringing these amendments forward as they point to an important observation on Schedules 3 and 4 of the bill. I agree that the insertion of a separate heading for religious activities is a helpful addition. I also note that Alistair Allen's amendments 214 and 218 will, apart from the insertion of the new heading, have the same effect as amendments 163 and 180 in my name. In principle, I am not opposed to Alistair Allen's amendments. My officials brought this matter to my attention after he raised it with them at the evidence session prior to stage 2 proceedings, and it was our intention to ask the parliamentary clerks to arrange for headings in italics to be inserted into the schedules administratively as printing changes to the bill. This would have allowed us to insert a heading in italics above paragraph 27 of Schedule 3 and paragraph 19 of Schedule 4, creating a separate category of religious activities as distinct from leisure activities. However, these amendments preempt and are consistent with our plans. For further clarity, we can request a new italic heading before paragraphs 28 of Schedule 3 and paragraph 20 of Schedule 4 as sports activities. I thank Ian Gray for amendments 215, 216, 219 and 220 in his name. Amendment 215 will make it explicit on the face of the bill that individuals providing support to a protected adult under a shared life scheme are carrying out a regulated role. Amendment 220 provides definitions of shared life agreement, shared life carer and shared life scheme for the purpose of Amendment 215. In his evidence before the committee, Ben Hall from Shared Lives Plus drew parallels between Shared Lives carers and foster carers. Mr Hall acknowledged that Shared Lives carers will be brought into the mandatory PVG scheme by some of the other activities in Schedule 4. I agree with that position, but I recognise that Ian Gray's amendments offer a helpful addition that capture the uniqueness of the shared life model of care. Accordingly, I have no objections to Amendment 215 and 220 in Ian Gray's name. In regards to Amendments 216 and 219 in Ian Gray's name, these will bring other individuals aged 18 or over into the mandatory PVG scheme by dint of who they live with. Under the current legislation, an enhanced disclosure with suitability checks, that is, a check of the barred list, can be required for an individual over the age of 16 residing in the same household as an individual being assessed as to their suitability to be a foster carer within the meaning of Section 96 of the PVG Act. Amendment 216 and 219 go much further than this. They mean that individuals aged 18 or over would be brought into the PVG scheme due to who they live with rather than as a result of the role they are actively carrying out. I therefore do not consider Amendment 216 to be appropriate. I agree there should be parity between individuals residing in the same household as a foster carer and a shared lives carer, and that the latter should be eligible to receive a Level 2 disclosure. Eligibility for Level 2 disclosures without PVG membership is not set out in the face of the bill. Instead, it will be a matter for secondary legislation and will be achieved through an amendment to the Rehabilitation of Offenders Act 1974, Exclusions and Exceptions, Scotland Order 21/2013. As part of implementation of the bill, I would be happy to speak further with Ian Gray if he would like to discuss how this work can be taken forward. I move Amendment 150. If moved, I ask committee members to support Alistair Allen's amendments 213, 214, 217 and 218. If moved, I ask members to support Ian Gray's amendments 215 and 220. I ask Ian Gray not to move amendments 216 and 219, but if pressed to a vote, I would ask that members reject amendments 216 and 219 in this group.
Thank you. Can I invite Dr Allen to speak to amendments 213 and the other amendments in the group?
Thank you, Convener. The four amendments the Minister has mentioned in my name deal with two relatively minor but I think important issues. and as she's mentioned, they deal with Schedules 3 and 4 of the bill, which presently class religion under leisure activities. The two issues that I'm attempting to address here in my amendments are firstly an equalities issue. I think probably members of faith groups are unlikely to think of their activities in the same bracket as a golf club, so that the term leisure activities is probably unhelpful. But more practically, a number of faith communities have contacted me just to mention that this fact has caused some, or risks causing some confusion when people are actually engaging with the legislation in future, and that it would simply be easier to correct the categorisation of religious activities. And with that in mind, Amendment 213 will strike the religious activities paragraph under the leisure activities section of Schedule 3, page 82, line 21. Amendment 214 will add a new religious activities section at the end of Schedule 3, page 82, line 22. Amendment 217 will strike the religious activities paragraph under the leisure activities section of Schedule 4, page 87, line 22. And Amendment 218 will add a new religious activities section at the end of Schedule 4, page 87, line 24. By adopting these amendments, we can, I hope, simplify and make more efficient the process of disclosure within our faith communities. Small points, as I say, but hopefully helpful ones. And if nothing else, I think, Minister, we've learned about the importance of italics in legislation, and we'll watch out for that in future from what you've said. Thank you.
Thank you. Can I invite Mr Gray to speak to Amendment 215 and the other amendments in the group?
Thank you very much. The Minister has largely already covered the purpose of these amendments, which, as she indicated, did arise from evidence given by Shared Life Scotland from Ben Hall in the course of pre-legislative scrutiny of the bill. Shared Life Scotland's concern was that the care model which they pursue be properly caught by the legislation, and they saw that as largely paralleling the arrangements for foster families. The difference being, of course, that in the Shared Lives model, of which there are 15 schemes now in Scotland, a growing number every year, those who live with a family are not children, but an adult, often with learning disability, or increasingly, in fact, an adult who suffers from dementia in their later years. I've listened carefully to the Minister's comments, and I think on the basis of what she said, I'm certainly prepared not to move 216 and 219 when the time comes, but to work with her prior to stage 3 and with Shared Lives to try and ensure that we do achieve that objective. If she thinks that can be done better in regulation, I'm sure they would be prepared to talk about that.
Thank you very much. Do any other members wish to take part? Minister, do you wish to wind up?
No, other than to say I'm very willing to work with Ian Gray and Shared Lives and stakeholders to make sure we get those amendments right.
Thank you very much. The question is that Amendment 150 be agreed. Are we all agreed? I call Amendments 151 to 162 in the name of the Minister and all previously debated, and invite the Minister to move Amendments 151 to 162 on block. Moved on block. Does any member object to a single question we put in Amendments 151 to 162? The question is that Amendments 151 to 162 are agreed. Are we all agreed? I call Amendment 213 in the name of Alistair Allen, already debated with Amendment 150. I remind members that if Amendment 213 is agreed, I cannot call Amendment 163 because of preemption. Dr Allen, to move or not move?
Moved.
Question is that Amendment 213 be agreed. Are we all agreed? I call Amendment 214 in the name of Alistair Allen, already debated with Amendment 150, and ask Dr Allen to move or not move.
Moved.
The question is that Amendment 214 be agreed. Are we all agreed? I call Amendment 224 in the name of Alex Cole-Hamilton, already debated with Amendment 222, and ask Mr Cole-Hamilton to move or not move.
Moved.
The question is that Amendment 224 be agreed. Are we all agreed?
No.
There will be a division. Can I call for those in favour of Amendment 224 to raise their hands? And those against? And the vote was 1 for yes and 10 for no, so 224 is not agreed. I call Amendment 225 in the name of Mr Cole-Hamilton, already debated with Amendment 222. Ask Mr Cole-Hamilton to move or not move.
Moved, convener.
The question is that Amendment 225 be agreed. Are we all agreed? Move to division. Can I ask those in favour of Amendment 225 to please raise their hands? And those against? The result of the vote is 1 for yes, 10 for no, so Amendment 225 is not agreed. I call Amendment 226 in the name of Mr Cole-Hamilton, already debated with Amendment 222. Ask Mr Cole-Hamilton to move or not move.
Not moved, convener. And with your permission, I can see the day is lost, so I would like to withdraw all remaining amendments in my name and not press them, if that's possible.
Thank you. That's very helpful, Mr Cole-Hamilton. Thank you. The question is that Schedule 3 be agreed to. Are we all agreed? Thank you. Call amendments 164 to 176 in the name of the Minister and all previously debated, and invite the Minister to move amendments 164 to 176 en bloc.
Moved en bloc.
Does any member object to a question, single question being put on amendments 164 to 176? No. The question is that amendments 164 to 176 are agreed. Agreed. Thank you very much. I call amendment 215 in the name of Mr Gray, already debated with amendment 150, and ask Mr Gray to move or not move.
Moved.
The question is that amendment 215 be agreed. Are we all agreed? Yes. I call amendment 216 in the name of Mr Gray, already debated with amendment 150, and ask Mr Gray to move or not move.
Not moved.
Thank you. I call amendment 177, 178 and 179 in the name of the Minister, all previously debated. Invite the Ministers to move 177 to 179 en bloc.
Moved en bloc.
Does any member object to a single question being put on amendments 177 to 179? No. The question is that amendments 177 to 179 are agreed to. Thank you. Call amendment 217 in the name of Dr Allen, already debated with amendment 150. I remind members that Amendment 217 is agreed to. I cannot call Amendment 180. I invite Dr Allen to move or not move.
Moved.
The question is that Amendment 217 be agreed. Are we all agreed?
Agreed.
Thank you. I call Amendment 218 in the name of Alistair Allen, already debated with Amendment 150, and ask Dr Allen to move or not move.
Moved.
The question is that Amendment 218 is agreed. Are we all agreed? Thank you. Call amendment 227 in the name of Cole-Hamilton, in the name of Alex Cole-Hamilton, already debated, and as Mr Hamilton has indicated he doesn't want to move the amendment. Does any other member of the committee wish to move this amendment? No. Thank you. I call amendment 228. Again, Mr Cole-Hamilton has indicated he does not wish to move this amendment. Does any other member wish to move this? No. I call amendment 219 in the name of Mr Gray, already debated with amendment 150, and ask Mr Gray to move or not move.
Not moved.
Thank you. I call amendment 220 in the name of Mr Gray, already debated with amendment 150. Mr Gray to move or not move.
Moved.
The question is that amendment 220 be agreed. Are we all agreed? Yes. I call amendment 229 in the name of Mr Cole-Hamilton. He has indicated he does not want to move this. Does any other member wish to move this amendment? No. Thank you. The question is... The question is that Schedule 4 be agreed to. Are we all agreed? Thank you. Now move to PVG Act, meaning of protected adult, and I call amendment 181 in the name of the Minister, grouped with amendment 182, 183 and 184 and 185, and ask the Minister to move amendment 181 and speak to all the amendments in the group.
Thank you, Convener. The existing definition of protected adult in the PVG Act relies on a person being in receipt of a particular type of service, health, social, community or welfare. Experience of operating the PVG scheme has shown that this definition is challenging in practice. Accordingly, when the policy for the bill was being developed and consulted on, it was proposed to amend the definition of protected adult in section 94 of the PVG Act and insert a new Schedule 3 to the PVG Act. This allows the new definition of protected adult to tie in with the new concept of regulated roles, which will replace regulated work. However, stakeholder responses to the bill have indicated that the move away from references to specific types of services and replacing those with references to the characteristic of the individual in receipt of them, illness, old age, physical or mental disability, and a resulting impaired ability to protect oneself from harm or requiring assistance with the activities of daily life, may lead to some people falling outside the definition in the amended Section 94 who would previously have been caught by the existing Section 94. Amendment 181 replaces the words old age with infirmity or ageing as a factor which, if it results in an individual having an impaired ability to protect themselves from physical or psychological harm or requiring assistance with the activities of daily living, will meet the definition of protected adult. Stakeholders reported some concerns about the adverse connotations of the term old age. This revised wording of infirmity or ageing clarifies who may be brought into the scope of being a protected adult. The word significantly is removed from the test of whether the person's ability to protect themselves from physical or psychological harm is impaired by Amendment 182. Scottish Women's Aid raised concerns that reference to a significant impairment would lead to vulnerable people being excluded from protection. Amendment 182 responds to that concern. Similarly, Amendment 183 responds to feedback that individuals who are homeless or affected by domestic abuse should be included within the definition of protected adult. Amendment 183 brings such individuals within the meaning of protected adult, but only in relation to a regulated role that involves the carrying out of activities mentioned in paragraph 16 of Schedule 4 of the Bill, provision of counselling, therapy, advice or guidance in relation to health or well-being to protected adults. This restriction is necessary to ensure that we do not disproportionately draw people into the scheme. As noted, the definition of protected adult is complicated and has been difficult for PVG users to navigate in practice. Amendment 184 affords ministers with a degree of flexibility and future-proofs the bill so that amendments can be made to the definition of protected adult to ensure sufficient coverage is provided by the PVG scheme. These are the same type of services currently provided for under Section 94 of the PVG Act. Amendment 185 is technical in nature. It provides a meaning for domestic abuse and as such is consequential on Amendment 183 and also contains some consequential amendments to provisions in Section 94 of the PVG Act that define certain terms to ensure that those definitions continue to work in the light of Amendment 184. The definitions themselves aren't altered in any way. We have listened, however, carefully to the views of stakeholders, and I am aware that there are still some concerns. I am interested in hearing the views of members in the debate today, and I am happy to work together to find a solution before stage 3. I will not move Amendment 185. I move Amendment 181.
Thank you, Minister. Do any members wish to comment? Ms. Bishop.
Thank you, Convener. I would just, I note the Minister has said she's not going to move Amendment 185. I should, before I speak, say that I am a trustee of Shetland Women's Aid, which comes under the umbrella of Scottish Women's Aid. But in terms of the Amendment 185, there is still concern about the definition of domestic abuse, so I'm encouraged by the comments from the Minister that continue to work on that. Thank you.
Thank you. Any other member wish to say? Mr. Green?
Thank you. It was just briefly to echo some of those comments and to thank Scottish Women's Aid for their submission to members. I found it very helpful. We had originally planned to support the amendment had it been pursued by the Minister, but in light of the comments made, it feels like there is still some work to be done around this. I think it does raise a wider issue, though, around the redefinition of vulnerable individuals. For example, on an initial glance of this, I had some questions around Amendment 18528A, where it said an individual who has experienced abuse, and I guess a question was given to me is that if someone who historically had unfortunately been a victim of abuse as defined here would be caught under current definitions of still being a vulnerable person, even if this had taken place many years, decades ago, and had wished to move on in life and did not want to be defined currently as a vulnerable person. And I wondered if that amendment as drafted really encompassed all scenarios. There is very difficult in legislation to encompass the individuality of people's circumstances. I do appreciate that. But I think certainly we all want to get this right, but we don't want to catch all people in legislation as being defined as a vulnerable or need to be protected simply by default due to historic circumstances. So I wonder if that's something the Minister might reflect on as we move forward on this. And just on this, and the flexibility that the Minister mentioned, specifically in relation to 184, I appreciate that flexibility seems to be required in this instance, but I wonder what scrutiny will be afforded to the Committee or Parliament if Ministers seek to redefine any of the definitions she detailed within that flexibility.
Any other member wish to come in? No. Minister, would you like to respond?
Thank you. Officials have discussed this group of amendments with the Scottish Women's Aid, and I am aware of their comments. I acknowledge their concerns that current drafting in Amendment 185 could be unduly narrow compared to the common understanding of what may amount to domestic abuse. I think it is important for us to provide a definition within the bill, as without it there would be uncertainty as to who is covered by Amendment 183. With Amendment 185, we sought to tap into definitions used in existing legislation to help to define the term, and they were intended to be broad. But in view of stakeholders' feedback and today's debate, I will not move Amendment 185. I'll instruct my officials to continue to engage with relevant stakeholders, including Scottish Women's Aid, ahead of Stage 3 to see that we can bring forward a revised amendment in this respect. And as ever, I am more than happy to work with any member of the committee who wishes to be involved in finding that appropriate solution to the concerns that are being raised by stakeholders.
Thank you, Minister. The question is that Amendment 181 be agreed. Are we all agreed? Thank you. I call Amendments 182, 183 and 184 all in the name of the Minister and previously debated, and invite the Ministers to move Amendments 182 to 184 on block.
Moved on block.
Does anyone object to a single question being put on Amendments 182 to 184? So the question is that Amendments 182 to 184 are agreed. Are we all agreed? Thank you. I call Amendment 185 in the name of the Minister and previously debated, and ask the Minister to move or not move.
Not moved.
Thank you. The question is that Section 76 be agreed to. Are we all agreed? So, we now move to consideration of listing, and I call Amendment 186 in the name of the Minister, grouped with amendments as shown in the groupings. I invite the Minister to move Amendment 186 and speak to all the amendments in the group.
Thank you, Convener. Section 30 of the PVG Act provides that ministers must inform certain persons of a decision to consider a person for listing, a decision to list a person, or, as the case may be, a decision not to list someone. Those persons are the individual concerned, organisations the individual does regulated roles for, and relevant regulatory bodies. As it stands, the bill will allow ministers to notify an individual who employs others not in the course of business that a scheme member is being considered for listing and has standard conditions imposed. These personal employers, as they are known, are typically individuals who pay for their child's music tutor or someone employing a carer within the context of self-directed support. However, the bill and PVG Act as they stand do not provide for ministers to notify those same personal employers of the final outcome of the consideration of the process, i.e. whether someone carrying out a regulated role for them has or has not been listed. These amendments address what I consider to be a potential safeguarding loophole, improving the protections for private individuals who use PVG scheme members. On a related issue, the amendments make it clear that personnel suppliers are covered by the Section 30 notification provisions in the PVG Act. Finally, there are technical amendments in this group to ensure that personal employers are not criminalised under the bill in relation to a failure to ensure that a scheme member complies with the conditions imposed on them. The amendments make it clear that personal employers are not covered by these offences, which is consistent with the other offence provisions for employers in the PVG Act, which only apply to organisational employers and personal suppliers. I move Amendment 186.
Thank you, Minister. Any members wish to comment? Minister, do you wish to wind up? No. Our question is that Amendment 186 be agreed to. Are we all agreed? Thank you. I call Amendments 187, 188, 189 and 190 in the name of the Minister, all previously debated. I invite the Minister to move Amendments 187 to 190 on block.
Moved on block.
Does any member object to a single question being put on Amendments 187 to 190? The question is that Amendments 187 to 190 are agreed. Are we all agreed? Thank you. The question is that Section 77 be agreed. Are we all agreed? Thank you. Call Amendments 191, 192 and 193, all in the name of the Minister and previously debated, and invite the Minister to move Amendments 191 to 193 on block.
Moved on block.
Does any member object to a single question being put on Amendments 191 to 193? The question is that Amendments 191 to 193 are agreed. Are we all agreed? Question is that Section 78 be agreed. Are we all agreed? Call Amendments 194 in the name of the Minister already debated with Amendment 186. Minister to move formally.
Moved.
And the question is that Amendment 194 be agreed. Are we all agreed? I call Amendment 195 in the name of the Minister already debated with Amendment 186 and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 195 be agreed. Are we all agreed? The question is that Section 79 be agreed. Are we all agreed? And the question is that Sections 80 to 83 be agreed. Are we all agreed? We now move to PVG Act removal of the lists and call Amendment 196 in the name of the Minister, group with Amendments 197 and 198. Invite the Minister to move Amendment 196 and speak to the amendments in the group.
Thank you, Convener. These amendments concern elements of the PVG Act barring service and how these can be improved. They are principally concerned with ensuring that the right people remain on the bar lists and the right people are removed from the lists. Amendment 196 changes the test in Section 25 of the PVG Act relating to applications for removal from the lists so that it more explicitly reflects the filtering nature of the provision. Disclosure Scotland's experience of applying the competence test under Section 25(3)(b) of the PVG Act is that the threshold of such that ministers should consider the application is insufficiently clear. This is because there will be changes in circumstance which would not be relevant to a determination by ministers about whether the applicant was no longer unsuitable to carry out regulated roles with either children or adults. For instance, an individual changing career is a change of circumstances, but not one relevant to the decision that ministers must make under Section 26 about whether the individual is no longer unsuitable to carry out a regulated role with either children or adults. An application that includes details of that sort of change in circumstances would therefore be incompetent, as it would not meet the threshold test under Section 25(3)(b). On the other hand, where a change of circumstances was relevant to the test applicable under Section 26, the threshold is cleared, and that application should be properly determined under Section 26 on the merits of the specific change. This amendment makes it more clear that a change in circumstances must be relevant to the determination to be made under Section 26 of the PVG Act. Subsection 4 of the new section introduced by the amendment repeals subsections 5 and 6 of Section 25 in the PVG Act. Disclosure Scotland's experience is that Section 25(5) and 25(6) may serve to confuse applicants and create a false impression that a conviction being quashed will automatically lead to someone's removal from the list. This is not the case, since there are different standards of proof for a criminal finding of guilt beyond reasonable doubt and the civil standard for listing decisions' balance of probabilities. Therefore, while a conviction being quashed might be a relevant change in circumstances leading to a competent application for determination under Section 26, it will not always be relevant. The revised explanatory notes will make that clear. Amendment 197 expands the possibility of late representations or additional information being used after a listing decision is made, so that ministers will have the option to remove that person from the list if they are satisfied that they are not unsuitable to carry out regulated roles of the type they were listed for. This addresses our concern that some people fall into the gap between the removal provisions in the PVG Act, and there is no way for them to be removed from the list, even if Disclosure Scotland think they should be. For instance, an individual who was invited to make representations but did not do so for whatever reason has no basis for asking ministers to remove them unless they could establish a change in circumstances and make an application for removal under Section 25. The reason for that is the test under Section 29(1)(b) is that ministers must be satisfied that the individual should not have been listed. The test of whether someone should not have been listed is not necessarily the same as a test of whether they would not have been listed if the information had been available at the time of the original decision. As it stands, the only remedy for someone in such a situation would be to appeal against listing under Section 21 or 22. What we are seeking to do here is eliminate this step so that should late representations or additional information be available subsequently, ministers have the discretion to remove that person from the list if they are satisfied that they are no longer unsuitable to carry out regulated roles of the type they were listed for. Amendment 198 relates to the information gathering powers available to ministers under Section 18, 19 and 20 of the PVG Act. The power to obtain information ends when the initial listing decision has been taken, except where there is formal application for removal from the list under Sections 25 and 26. In other circumstances where there is any future consideration by ministers regarding whether an individual ought to be removed from the list, including under new powers provided for in Amendment 197, ministers have no power to obtain information from the police or any other bodies. The new provision broadens the powers to obtain information to apply in relation to all decisions that are to be made by ministers, including a decision about whether someone should stay on the list at a later date. It is appropriate for ministers to have information gathering powers where they are making a decision at a later date, for instance, in relation to an appeal against listing, an application for removal from the list, or whether to remove an individual from one of the lists. Ministers' role at these subsequent stages of decision-making is the same in substance as the original decision to list an individual. The information gathering powers are necessary and appropriate in the context of ministers' statutory functions to operate the PVG scheme and barring service. Amendments 196, 197 and 198 should therefore be seen as a package of changes which ensure the right people remain on the barred lists and the right people are removed from the barred lists. I move Amendment 196.
Minister, does any member wish to make comment? Mr. Green?
Thanks. Thanks for affording me some time just to briefly ask the Minister. There's quite a lot to take in there. It's the sort of thing you'd probably benefit from reading rather than listening to. It's technically intense. But any time in legislation I spot the words minister's powers, they always jump out at me. So my question really simply is, are these additional minister's powers to remove from the list powers that the minister already can exercise under the existing legislation, or are these additional ministerial powers? Because using phrases like where ministers consider it appropriate or at minister's discretion surely by default injects an element of subjectivity into process, which I would have assumed Disclosure Scotland is fairly watertight. So, briefly, what are these additional powers and why do you need them?
Does any other member wish to make comment? No. Minister, would you like to respond?
Okay, so there are additional powers. What they do is align with the powers available to ministers to gather information at the time the original barring decision was made. So it is, we think, appropriate for ministers to also be able to gather information at the time when decisions are made with regard to removing someone from the list. And there is... I think that answers your question. Is that?
I think
I mean, if you have a concern, I'm more than happy to consider that between now and stage 3. It is simply the powers required to operate the system as we would hope it should operate.
Okay, thank you, Minister. The question is that Amendment 196 be agreed. Are we all agreed? I call Amendment 197 in the name of the Minister already debated and ask the Minister to move.
Moved.
Thank you. The question is that Amendment 197 be agreed. Are we all agreed? I call Amendment 198 in the name of the Minister already debated with 196. Minister to move.
Moved.
Thank you. Question is that Amendment 198 be agreed. Are we all agreed? Question is that sections 84 and 85 be agreed. Are we all agreed? Thank you. We now move to the offences outside Scotland section. Call Amendment 199 in the name of the Minister in a group on its own and ask the Minister to move and speak to Amendment 199.
Thank you, Convener. Amendment 199 is a technical amendment to ensure that jurisdiction for the new extraterritorial offences in the bill is conferred on the Sheriff Courts. The policy intent of the provisions in the bill is to bring overseas work, which would have been a regulated role if done in Scotland, into the PVG scheme, where there is a relevant connection to Scotland, for instance, if the employing organisation sending the individual overseas is based in Scotland. This is intended to address situations where, for instance, a Scottish charity sends aid workers to another country to do what would be considered a regulated role here. The Scottish Government's intention is that those people should have to be scheme members. The current drafting is such that the general rules on scheme membership, including the offence provisions, should automatically apply to such overseas roles. They would also apply where an organisation based outside Scotland was sending someone to do a regulated role in Scotland. However, it is also necessary to ensure that offences committed outside Scotland can be prosecuted here to give full force to the new provisions. The amendment ensures that Scottish courts have clear jurisdiction over offences under the PVG Act, whether the behaviour giving rise to the offence takes place in Scotland or elsewhere. I move Amendment 199.
Thank you. Does anybody wish to make comment? No. Okay. Do you wish to wind up, Minister? Thank you. The question is that Amendment 199 be agreed. Are we all agreed? Call Amendment 200 in the name of the Minister, already debated with Amendment 3. Ask Minister to move.
Move.
Thank you. Question is that Amendment 200 be agreed to. Are we all agreed? Thank you. Question is that Section 86 be agreed to. Are we all agreed? I call Amendment 221 in the name of Daniel Johnson, already debated with Amendment 112, and ask Mr Johnson to move or not move.
Not moved.
Thank you, Mr Johnson. The question is that Section 87 be agreed to. Are we all agreed? The question is that Sections 88 and 89 be agreed to. Are we all agreed? Thank you. Call Amendments 201, 202 and 203 in the name of the Minister and previously debated, and invite the Minister to move 201 to 203 on block.
Moved on block.
Does any member object to a single question being put on Amendments 201 to 203? The question is that Amendments 201, 202 and 203 agreed. Are we all agreed? Thank you. Move to consequential amendments to the Age of Criminal Responsibility Act 2019. I call Amendment 204 in the name of the Minister, group with Amendment 207. Minister to move the amendment and speak to both amendments in the group.
Thank you, Convener. Amendments 204 and 207 make amendments to the Age of Criminal Responsibility Scotland Act 2019 that are consequential on parts 1 and 2 respectively of the bill. The Age of Criminal Responsibility Act makes reference to the Police Act 1997 and the Protection of Vulnerable Groups Scotland Act 2007 and disclosures issued under those acts, namely enhanced disclosures and scheme record disclosures. The bill repeals some sections of the PVG Act and Part 5 of the Police Act in its entirety. Amendment 204 replaces these repealed and superseded references with references to the new form of Level 2 disclosures issued under the bill. The amendment also ensures that there is symmetry between the content of a Level 2 disclosure and a PVG scheme record. Finally, where relevant behaviour information was originally provided as vetting information by the Chief Constable, but which the independent reviewer determined not to be included in a Level 2, that it no longer amounts to vetting information for the purposes of the PVG Act, such that it could trigger consideration of listing. Members will recall that in a previous grouping there were amendments to introduce a codified set of principles to apply to decisions made in applying the two-part test of whether something is relevant and ought to be included in a disclosure certificate. Amendments 112 and 202. Amendment 204 applies the same decision-making principles to decisions made under the Age of Criminal Responsibility Act. Amendment 207 makes a consequential amendment to Section 26 of the Age of Criminal Responsibility Act so that the definition of regulated work is substituted with a definition of regulated role in light of this new terminology in the bill. I move Amendment 204.
Thank you, Minister. Does any member wish to contribute? Well, Minister, do you wish to wind up? Thank you. The question is that Amendment 204 be agreed. Are we all agreed? Call Amendment 205 in the name of the Minister. Already debated with Amendment 3. Minister to move.
Moved.
Thank you. The question is that Amendment 205 be agreed. Are we all agreed? Call Amendment 206 in the name of the Minister. Already debated with Amendment 3 and ask the Minister to move.
Moved.
Thank you. The question is that Amendment 206 be agreed. Are we all agreed? Thank you. I call Amendment 203 in the name of Mr Cole Hamilton. Does any member... 230 in the name of Mr Cole Hamilton. Already debated with Amendment 222 and ask if any member wishes to move this amendment. Thank you. Call Amendment 231 in the name of Alex Cole Hamilton. Already debated with Amendment 222. Does anyone wish to move this amendment? Thank you. Call Amendment 207 in the name of the Minister. Already debated with Amendment 204 and ask the Minister to move.
Move.
The question is that Amendment 207 be agreed. Are we all agreed? Thank you. Question is that Schedule 5 be agreed. Are we all agreed? Question is that Sections 90 to 94 be agreed. Are we all agreed? Thank you. And the question is that the long title be agreed to. Are we all agreed? Yeah. Thank you very much. Can I thank the Minister and her officials for attendance today, and also thank the committee and all members who took part in our scrutiny of the bill at stage 2. I can also say that in closing proceedings, given a lot of the discussion that was had on amendments today, that we will be sending a copy of the OR to the Standards Committee following today's proceedings, and I now close the meeting. Thank you.